are a little bit limited on time, and we've had a huge amount of questions coming in. So apologies if we don't get round to yours. We did have a number come in early on just asking about applicability of the Act, which I think they've generally been answered throughout the course of the conversation, but if not, they are kind of outlined in the Act itself. So I'll refer.
Yes, I think I refer to high rises generally. It is residential high rise with 2 or more dwellings, residential dwellings.
Fabulous. Thanks for confirming, Dan. So a couple of the common themes that were coming up are around, does this apply to existing buildings that may have suspect cladding or defects that are discovered, during any kind of inspections? I don't know if there's a kind of response to that.
Sorry, Victoria, could you just repeat that? I just missed perhaps the key bit of that.
Yeah, no, a couple of people have queried, whether kind of provisions of the Act apply to if you've got an existing building which maybe has suspect cladding, or you detect kind of any potential defects or issues during kind of routine assessments. Does the Act apply to those, or actually is it only buildings? Is it only kind of new builds?
No, it is very much applicable to existing buildings as well. So if a defect were to be identified, then there is a procedure to be followed whereby the landlord has to act pretty quickly to notify all of the leaseholders of that defect if it has an intention to recover any part of the cost of remediating that defect from leaseholders. But yes, the key point is that it applies to existing buildings and new buildings.
Fantastic. Thanks for clarifying, James. Interestingly, there's a lot of questions coming in about delegation of responsibility, and that's kind of twofold. One is about delegation of owner responsibilities. So can a building owner delegate the responsibilities to, for example, a managing agent or similar?
Yeah, they can. I think this is under the accountable persons definition. There's specific provision for that. If a management agent takes on all the repairing obligations, they will take on the role of accountable person rather than the legal estate owner. I think that's in subsection 2 of the accountable person provisions.
And just to follow on from that, I mean, I'm seeing already that landlords and managing agents are scurrying to redraw terms, their commercial terms, to cover the increased liability brought back by the Act, because clearly there is quite a lot of increased liability, and the allocation of that is clearly important.
Absolutely. And on a kind of a similar vein, there's a lot of concern that perhaps, are HSE ready for this? And, are they going to be overwhelmed? And much in the way that, from a building control perspective, you can have delegated responsibility for that and outsource it. Is there going to be a similar mechanism in place should, HSE find that they just don't have the capacity to deal with this additional workload? I don't know if that's something any of you might know.
I'm not sure we're necessarily best to answer, but we'd certainly hope so. I mean, they've got enough on their plate as it is, the HSC. We deal with a number of HSC prosecutions in our team, and they are very busy, and hopefully they've taken on extra capacity.
Brilliant. And actually, a point that you just mentioned, James, taps into a couple of other questions. And so there's just a few more points, and then we'll bring this to a close. But there are a few people who are, justifiably querying around this kind of the issue of liability and particularly the retrospective act to it. So firstly, does this kind of extended liability apply to all elements of a building, even if actually potential or a development, including if some of those would sit outside the Act? And similarly, does that mean, people are sort of concerned if we're now talking about 30 years, previously where people have had insurance that covers them for 12 years, does that mean there is a period of 18 years which is effectively now unaccounted for?
Yes, I have replied to some of these people while my colleagues have been talking. But yes, in terms of the 18-year gap in insurance, the answer, I'm afraid, is yes. And this is why the industry is quite so worried about it. The one thing that I would say to try and lessen everybody's anxiety is that if a claimant is intending to bring litigation, they do obviously need evidence, because the way the legal system works is you have to prove your case. So there is a high likelihood that the evidence going back 30 years on any particular case is simply not going to be there. And one of the things that I mentioned was the changes in technology and how information was stored. So if there's no documentary evidence, you're going to be looking at witness statements instead. People may not still be around, they may not be working, they may have come to them, they're dead. There simply may not be the evidence available for a potential claimant to successfully bring litigation. So there's going to be a deal of weeding out at the very beginning of, yes, you may have a theoretical case, but in practice, are you actually going to get anywhere with it? So although we are expecting a lot of claims, it's not necessarily the case that everybody will be having a go at everybody, because it simply may not have anything that they can prove. What was the previous bit about? Does it apply to limitation periods? Apply to everything. The limitation periods apply because of the way that the Act is drafted. They extend the limitation periods under the Defective Premises Act and the Building Act. Now, the Building Act bit's not in force, so we don't have to worry about that. But what it means is that if you have a claim on the Defective Premises Act, that's when the limitation periods now apply. So if it's not a Defective Premises Act claim, then no, fundamentally, except for the construction products, which is a whole new area of claim. So it's to do with the way the Act is actually drafted and how it works.
Brilliant. Thank you, Darren. And I know we haven't been able to answer everyone's questions. I think what I would just do is encourage people, if you do have concerns, then please do speak to your own sort of insurers or sort of legal teams and make sure that, you've got all the information you need with regards to sort of how you operate and the business you're involved in. A couple of people have asked about, sort of what the institution is doing. As we mentioned at the start, obviously there is a whole program of sort of events and resources that will be coming up over the coming year, focused around the Building Safety Act, just to really sort of give people the knowledge that is needed to practice. Obviously, like everything, it comes down to competence, and we all need to only sort of operate in areas which we are competent in. So, that does still apply. And I think really that's sort of where we'll sort of bring it to a close for today. I mean, I would just like to say a huge thank you to Dan, Darren and James for giving us their time this morning and sort of bring us all as up to speed as we can be on this really important issue.